We're one of 30 some odd policy programs that make up the policy part of the Institute. We're absolutely delighted that you are here today. This program this afternoon is part of a broader program that we're sponsoring here all day, looking at guns or firearms in the common law. We spent all morning together, and once we're finished here, we're going back as well. But one of the things I want to just highlight that, or to emphasize, is that here at the Institute, we're beginning to look at the issue of gun violence from a public health perspective. You might be wondering, why is health medicine and society involved in this? So that's one of the issues that we're going to be focusing on. I know there's going to be a tremendous amount of interest in asking questions, so I want to get right to the program. Nina Totenberg, who's going to moderate, will introduce our panelists. I promised Nina I would not embarrass her with any kind of introduction, so this is my one-line introduction. Nina Totenberg, someone who needs no introduction.
Thank you. So if you don't listen to public radio, please do listen to public radio, and other than that, I'm not going to say anything. Our subject today is the Second Amendment and the relationship of history to law. So I thought it right that we begin by my reading the full, unedited text of the Second Amendment to the Constitution of the United States, and that, I guarantee you, does not take very long, as it is all of 27 words long. It reads, "A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed." Now, for most of our history, it seems to have been presumed that the amendment was written to guarantee arms for a militia. Indeed, in 1876, the Supreme Court ruled that the right to bear arms is, quote, not granted by the Constitution, neither is it dependent upon that instrument for its existence. And in 1939, the Supreme Court ruled that the federal government and the states could limit any weapon types not having a, quote, reasonable relationship to the preservation or efficiency of a well-regulated militia, close quote. So established was this doctrine that Chief Justice Warren Burger once famously dismissed as a, quote, fraud, the idea that the Constitution guarantees an individual right to own a gun. But in the decades that followed, there was considerable new scholarship conducted on what the Founding Fathers actually meant in the Second Amendment. And there was considerable political push as well. And lo and behold, in 2008, the Supreme Court ruled for the first time by a narrow 5-4 vote that the Constitution does guarantee an individual right to own and keep in one's home a gun for the purposes of self-defense. The case invalidated a ban on handguns in the District of Columbia. 2 years later, the court upheld that right for those living in the states, not just those living in the federal city. So we meet here today to discuss how this turnaround took place in the law, how far-reaching pragmatically it in fact is, and what it portends for the future. Our guests are Darrell Miller from Duke University Law School and Eugene Volokh from UCLA Law School, both of whom have written extensively on all of this, and will probably correct my summaries. And I'm going to give them each 3 minutes to open. They can take all 3, they can take less. If they start to wander into 4, the long arm of Nina will reach out. And then I'm going to ask them a few questions, and they presumably can ask each other questions as well, and then you all will get a chance. Gentlemen.
I really appreciate it, and thanks to the Aspen Institute for convening this really incredible event. There's been another session with many historians that I respect on this issue and really enjoy the opportunity to talk. So, as Nina had said, the case of District of Columbia versus Heller, which is the 2008 opinion, basically closed the door on one era of Second Amendment debate. That is between what was known as the individual right and what was sometimes known as the collective right. The idea being that there was a split between camps as to whether the Second Amendment text was focused more on the individual right to keep and bear arms, or only a right to keep and bear arms within the context of militia service. And so the Heller case and its sequel, McDonald versus City of Chicago, basically closed the door on that debate and said that the right is an individual right. But it said in both opinions that there's still plenty of room for regulation. One of the central quotes that comes up again and again in litigation, for example, is the quote from Heller that nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of arms into sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Not much guidance, though, exactly about how the lower courts are supposed to answer Second Amendment questions. It seems like history is playing a big role in the issue, but how much history plays a role is going to be part of what I'm sure we'll talk about in the Q&A. So far, lower courts have fashioned what is typically known as a sort of categoric and balancing approach, trying to figure out, first, are we dealing with a Second Amendment question at all? Are we talking about something that comes within the text of being an arm, or being a bearing, or keeping? And then once we get to that decision, then some kind of tailoring or balancing of various interests of the government and regulation versus the interests of the person in their right. And finally, because I only got a few minutes, I would be remiss, I'd be doing sort of panelist malpractice if I didn't mention originalism. I'm going to get too technical, but Heller is typically understood as kind of the apogee of an interpretive enterprise that began with Ed Meese in the 80s, called originalism, which is that the Constitution means either what the framers of the Constitution intended, or a more sophisticated version is what a ordinary speaker of English would understand these words to mean in 1791, at the time that the Second Amendment was ratified. And so the idea is that that is our sort of guiding star in terms of constitutional meaning, is either intent or the generation that actually ratified the document. And with that, I think my 3 minutes are probably way up.
Yeah.
Yep.
Mm-hmm.
Thanks very much to the Aspen Institute for organizing this and for having me here. Law, somebody once said, is the only discipline in which the phrase, "that's an original idea," is a pejorative. Law is always tied into history. Now, it can be tied in several different ways. One is to the extent that, excuse me, that one believes that original meaning, what a phrase meant to those who enacted it, is relevant to the interpretation of either constitutions or texts. That is actually not a tremendously controversial idea. Justice Brennan routinely used originalism, for example, in the Establishment Clause context, and occasionally in free speech in other areas as well. There is the sense that judges and scholars are more likely to use original meaning arguments when they like the evidence that supports their views, but whatever one might think of how thoroughly or how candidly people use it, the notion that original meaning is at the very least relevant is been broadly accepted by the wide range of judges, not all scholars, but a very wide range of judges and a very wide range of scholars. I should also say that the notion that original meaning is basically binding is a very old notion in American law as well. In state courts interpreting the state constitution, for example, it is basically the dominant view, at least as expressed, perhaps not always as practiced, and has been since the early 1800s. In federal courts, it has at times been mentioned as well. It's true that the notion of the Supreme Court interpreting the Constitution with originalism being the dominant mode when original evidence is sufficient. That is indeed something that was more forcefully advanced since the 1980s. But originalism more broadly has been around for a very long time. So history is important to that. History is also important insofar as tradition goes. Heller talked about traditionally recognized things. Here I want to disagree a bit with Nina. In fact, actually, the tradition of the right to bear arms generally, and the Second Amendment in particular, has been mostly, I think, an individual rights tradition throughout most of American history, but not the overwhelming majority of it, at least in courts. Throughout the 1800s, there were repeated references in treatises and in court opinions to the right being an individual right. Cruikshank, the 1876 case, simply said that the right is not something that's incorporated against the states, because that was the question there, and also did not apply to private conspiracies. That was really the question there, private conspiracy, I believe, a part of Klansmen to disarm blacks. But in 1893, for example, in Robertson v. Baldwin, the court listed the Second Amendment is just in a list of individual rights, albeit limited ones. It stressed that the right to concealed carry was not included within it. From the early 1900s, and especially the late 1930s, to the 1980s, in federal courts, the dominant view was that of states' rights or militia rights rather than individual rights. But I think that is the aberration throughout American history, albeit a long one and a significant one. The third way in which it's relevant is simply precedent, and understanding precedent in context and understanding what it meant. Judges pay attention to precedent. Some think they should pay more attention, some less, but they can't help it. You can't look at every case entirely afresh. So when we've got questions like, for example, does the federal ban on 18 to 20-year-olds buying handguns from licensed dealers, is that constitutional or not? That was an issue the Fifth Circuit faced, and ultimately panel said, I think 2-1, that it's constitutional, and then the en banc court said 7-7 that they won't rehear it. It was a tie vote. You look at the opinions, and they're all about history. They're all about how, throughout American history, 18 to 20-year-olds were treated in this respect. So history ends up being tremendously important in all of these areas, but in three different ways, both original meaning and tradition and precedent, with different weights placed on each.
Can I just? Mm-hmm. So, is this thing on? Yeah. So I think I agree with what Eugene has said. And I think I'll offer what I would like to think is a friendly amendment, which is, part of the debate about the use of history is what he was saying in terms of, is it an individual right? Was it a militia right? Well, yes, if you say what was the common understanding of people about their rights vis-a-vis firearms, up until the 2008 decision. If you think of that as being, in some sense, constitutional law, and Reva Siegel at Yale has written a very good piece on this and saying that people sort of understood that they had a right, and that's what really constitutional law is, then what Eugene has said is absolutely correct. Or if you understand it in terms of just something out there in the atmosphere that is waiting to be found or confirmed by the Supreme Court. But if you think of it in the sense that Brennan said, which is, I got 5 votes, and that's what the law is, well, then the right really wasn't an individual right until 2008. Now, the opinion in Heller says, we found this right, we've discovered it, it's been hidden for several hundred years or forgotten, and that is one kind of way of approaching constitutional history and constitutional law, but it's not a way that we usually think about sort of constitution.
So I'm going to interrupt you here.
Sure.
Heller goes on for many, many pages, and so do the dissents. But the crux for pragmatists, for people who want to know what's going to happen, and I'm the bottom line person here, I'm the reporter, is that section saying that Scalia wrote, like most rights, this one is not unlimited. Since the 19th century, he observed, limits on carrying concealed weapons were lawful under the Second Amendment. And then he said, while we don't undertake an exhaustive analysis of the full scope of the Second Amendment, nothing in our opinion should be taken, et cetera, the part that you read. So, and he enumerates a lot of things, even though it's not exhaustive. And that's it. So let's go back to, and I'm going to give you an inside story. I was once the beneficiary of what could only be called a very telling Nino Scalia shrug. It was the weekend after Heller, and just coincidentally, the Scalias were coming to dinner at our house. My husband, who's a trauma surgeon, so he has views on guns, decided, first of all, that he was going to place in every soup bowl, prior to everybody getting up and serving themselves soup, a toy handgun. And then he took out from under the table a super soaker, a huge thing, and he points it at Nino and he says, "And I can still hold this with one hand and dial 911 with the other." So I said to the justice, you know, that section, the exhaustive, not going to have an exhaustive list section, doesn't really sound like you. It sounds more like your fifth vote, Justice Kennedy, alluding to what you just said. And here's the shrug part, he went, So that's all I can give you is, interpret it as you will. I certainly interpreted it one way. And so let's go back to that laundry list. And nothing, in our opinion, should be taken to cast doubt on the long-standing prohibition on the possession of firearms by felons. And yet, just I think last week or the week before, the Third Circuit Court of Appeals, in a sharply split opinion by the full court, not just a panel, ruled that the ban on felons owning firearms was unconstitutional. Now, the specifics all make it kind of muddy it up because technically these were state laws that were misdemeanors, but they were sufficiently long terms. One was it was a couple of DUIs and an unregistered gun, and the other was statutory rape. They're felonies by federal standards. So a felon is a felon, right? And where do you draw the line?
So I think it was Kant who famously said, out of the crooked timber of humanity, nothing straight was ever made. Well, imagine out of 5 pieces of crooked timber, how often are you going to make something that's completely logical? Not very. But I will say there is something quite Scalia about the notion of long-standing prohibitions being exempt. Justice Scalia is often thought of as an originalist, but Justice Thomas was the more thoroughgoing originalist. Justice Scalia was an originalist coupled with being a traditionalist. And he often said that quite explicitly. He said that as to the First Amendment, for example, when he was talking about, for instance, the patronage decisions, where he thought that patronage hiring and dismissal was constitutional. Why? Because it had been done throughout much of probably human history, but much of American history. And his view was, unless the original meaning or the text is extremely clear, we should treat traditions as kind of a dispositive judgment of the institutions of the American people as to what the meaning of the ambiguous text is. Now, of course, you can debate what's clear and what's ambiguous, but it is very Scalia to say, look, just because there's this right doesn't mean that it is absolute categorical and wipes away all of the tradition. Now, it's not quite as Scalia to leave things relatively vague. He likes clear rules, rule of laws, law of rules, although at the same time it is really quite rare for a decision that is the first one to expressly articulate the scope of an individual right to define it very precisely. I don't think Heller is the first Supreme Court decision to talk about the right as an individual, but it is the first one to specifically so hold, and so it's unsurprising that there would be some gaps there. So then what we get to is the process, which I think Justice Scalia and Justice Thomas and everybody else has long endorsed, which is what do you do? How, once you have the general scope of the right out there recognized, how do you implement it? How do you turn it into law? And you don't implement it just by reading the text, because often the text is not quite clear. It can be clear enough, or an original meaning can be clear enough as to the big picture, but often not the specific details. And you certainly don't interpret the text of court decisions as if they were statutes. The Supreme Court had specifically talked about that. So for example, when you talk about presumptive certain things being presumptively valid, such as disqualification of felons, there is always the question of what really counts as a felon. So for example, what about the statutory rape case is an excellent example. This is a 40-year-old having sex with a 17-year-old, which is behavior that is perfectly legal in 38 states and is called a misdemeanor under state law. But the potential punishment under state law was up to 5 years, I think in part because I think it was Pennsylvania that was the relevant state, just had all sorts of misdemeanors where they wanted to give the judge sentencing discretion. So that this particular guy was actually sentenced to no time in jail. But the statute under which he was sentenced theoretically made it possible to be punished up to 5 years, even though it's labeled a misdemeanor. Under the federal statutory rule, if a state labels something a misdemeanor, but the sentence is greater than 2 years, that's treated as a federal felony. So the question is, what's the constitutional significance of the word felons, as it were, or the concept felons? And I think the Third Circuit quite plausibly, although there was a split within the majority as to how to interpret it, as well as between the majority and the dissent, but at the very least I think the majority, the two opinions in the majority, were right to say not everything that is labeled felony under federal law ought to be treated as felony for constitutional purposes.
Does this show us why the court has been really loath to take gun cases?
Oh, I think the court has been loath to take gun cases, in part because 4 judges need to grant a review.
And they need a 5th to win.
Right, and they grant with an eye towards whether they're likely to get a 5th
Right.
to win. So if you have a situation of some uncertainty, then the judges might be quite reluctant to agree to hear the case, because what's the point of granting, of hearing a case unless you really feel there's such disagreement among lower courts and we've got to have a rule one way or the other? What's the point of granting only to be on the losing end of that vote? So I think that, more than just the unclarity of the or the difficulty of the problem, is the reason for the paucity of grants.
I think, I mean, the felon in possession rules, which is just one of these sort of categorical exceptions, sort of illustrates the problem, and it's probably why he got a shrug. You got a shrug at dinner, which is, it's many people have written, for example, that felon in possession rules, and certainly nonviolent felons, are 20th century inventions. So if long-standing means, just within the past, 50 some odd years, well, yeah, that's long-standing from my daughter's point of view, right? But that's not long-standing, in the long arc of history. And so the issue here is you've got a rule, you got these sort of categories where the court says, is using these as things that aren't even, one way of interpreting is, these aren't even Second Amendment issues. If you are a violent felon and you are caught with a gun, you don't even get to really raise, hey, I got a Second Amendment right, because the way the lower courts have dealt with that is say, it's categorically excluded. We don't even think about that type of keeping or that type of bearing as a Second Amendment protected right. What gets really problematic in the implementation, and I think that Eugene is absolutely correct, which is it's all about implementation, is this idea about categories, things that just aren't even Second Amendment concern, things that might be a Second Amendment concern, but we use some other type of rule or some type of influence to figure out whether or how it should come out. And the use of history in that. So, for example, one of the arguments, for example, of keeping 18 to 21-year-olds from being able to purchase firearms is that they would be analogous to somebody in the 18th century who didn't have sufficient virtue, had not shown sufficient virtue to be an arms bearer, and therefore they can be kept from keeping and bearing arms. Now, that's a strange exercise to us as opposed to a straightforward sort of calculation of what's the risk of harm versus the upside of having 18 to 21-year-olds being able to bear arms. But that's what the Heller opinion, at least in some interpretations, locks us into, and that's why we get this, the tension is between Scalia, the category guy, Scalia, the historian, Scalia, the traditional guy, and this sort of clause, what's sometimes known as the safe harbor, to get the fifth vote.
So, if I may just add one small thing about this, just to broaden the picture. Most gun control laws are state laws. And 44 of the 50 states have state constitutions that have a right to bear arms in them. It's very hard for me to see how any of those could be seen as a state right. Whatever you might say about securing a state right in the federal constitution against the federal government, you're not going to secure a right of the state or a right of the militia against the state itself. And in fact, almost all of them, either by their clear text or by their interpretations, have been read as individual rights provisions. These issues come up under those constitutions too, and will keep coming up. So the question of how do you reconcile an individual right to keep and bear arms with various kinds of gun control laws and decide which ones are constitutional and which are not has arisen before Heller and will continue under state constitutions.
But the whole conversation about what's appropriate, an appropriate individual right under the U.S. Constitution is framed in part by those state laws. So that if the Supreme Court were to say, you can have a ban on concealed carry unless you have a compelling reason to carry, security reason of some sort. If the Supreme Court were to say that, it would take the wind out of the sails of a lot of state legislators. At the moment, for example, and here I will cite my source, is actually The Daily Show. Last night I was watching. But in Missouri, they either have passed or are about to pass a statute which allows concealed carry by somebody who has no training whatsoever.
So let me disagree with you on that, except for the Missouri. That's exactly what's happened in Missouri. So in mid-1980s, 10 states were what one might loosely call shall-issue states, states in which any law-abiding adult pretty much could get a license to carry. The laws would say that the sheriff shall issue such a license, or in one state did not need a license. That state turns out to have been Vermont. Today, it's flipped. It's 40 states which are this way, and 10 states were what used to be the majority view. This isn't because of court decisions, except possibly in Illinois. This is because, at least of court decisions applying the Second Amendment. This is because of the political power of the gun rights movement, coupled with the fact that when the first few experiments were tried, chiefly in Florida, there were predictions that there'd be blood in the streets, and apparently the predictions have not been borne out. You might say, oh, that's still a bad idea to have shall issue, and there was some increase in crime. Some say it's increased, some say it's decreased, but the bottom line is the fears of massive just shootouts because people get angry at each other, that has not seemed to have borne out. Those are the reasons. The Supreme Court in Heller basically said that bans on concealed carry are constitutional. The majority, that was, as you pointed out, that was the first thing that they mentioned. And yet, long before Heller and since Heller, there has been this political move to ease concealed carry and provide shall issue. And I think that would continue even if the Supreme Court were to say, oh, we're going to specifically hold what we merely stated in Heller as to concealed carry.
I think it's important to remember because it gets it gets lost in all the sound and fury is that, you know, federal constitutional rights are generally thought of as a floor, right? They're not ceiling. So if states want to say every 2-year-old can have a gun, you know, it might be unwise, might not make a lot of sense, but they're perfectly free to do that. I think one of the issues is where is that conversation supposed to take place? Does it take place in a legislature? Does it take place among a polity in terms of amending a state constitution? Or does it take place within a federal litigation before the Supreme Court? The other thing I want to mention on the point that you made about concealed carry in Missouri and no training. Is many states, have open carry no prohibitions on open carry rules. I think many states, for example, don't necessarily require that there's going to be, I should say, not uniform in terms of the type of training. One of the things that I think is interesting is lots of states have a kind of policy that people should be able to carry their firearms for the protection of themselves and others, a kind of baked-in presumption that having a bunch of guns actually makes everyone better off. One of the interesting things that Eugene probably will remember is O'Connor, in an opinion once called Harris, said the paradigmatic failure to train, where a government had an obligation to do something and didn't, is to simply empower a bunch of people, police officers, with the ability to use deadly force and not train them at all on what the constitutional limitations on the use of that force is. And so it's interesting to think that something like that kind of experiment is going on, where you have this sort of radical democratization of the ability to use violence, but that it can only be solved after the fact. In the state that I live in North Carolina, it happened tragically. Somebody had said that there were people that were causing a disturbance. One person was walking by this person's house. He said that they had guns. He said that he was defending the neighborhood and shot this young man dead. Now, for every one of those anecdotes, I'm sure that Eugene and many other people have the opposite anecdote about somebody using a gun to save somebody. But again, the question is, where is that conversation supposed to happen?
Well, one of the interesting political aspects of all of this is that the driving force that we see today to oppose regulation at the federal level anyway is the NRA. Now the NRA, if you look back historically, it was always a gun rights organization, but it was mainly a sports organization. It was not a hugely political organization until it got an opponent on the right, the Gun Owners of America. And then, I'm not saying that the NRA was a lay down your arms kind of organization. It became far more vigilant in what it opposed. So that today, for example, there is a federal statute that bars the collection of data by the federal government on gun deaths, on gun injuries, and that kind of thing. So that
I'm sorry, I don't think there is such a statute.
It's actually part of the
Affordable Care Act.
yeah.
So there are statutes that limit the federal government from keeping data on particular gun owners, that they can't create databases based on of who owns guns. There's a statute that bars the Centers for Disease Control from advocating for gun control the way they advocate for
Right,
various
but it
other public
also
health
bars
measures.
them from collecting data.
All I know is the CDC Whiskers database, which you could access right now. It's a delightful database. Will give you data that CDC has collected on deaths by firearms and injuries by firearms and lots of other things. So maybe they're all a bunch of lawbreakers, but I don't think so.
It's the way it's collated, and so that the first actual real study that was conducted and was published this year, I think, either in the Journal of the American Medical Association or one of the main medical journals, was done by the trauma unit in Newark, at the public hospital in Newark, and it just had data that didn't exist before because the CDC couldn't collect it.
So I would love to see that. I have heard claims about it. I have not actually seen such a statute, and when I've tried to track it down, it's been either that, again, CDC can't advocate for gun control the way they do advocate for other policies, or cannot gather individual. But please, I'd be happy to be proven wrong.
I'll be happy to send
All
it to you. One of the things that there seems to be some debate about, at least in the gun rights, gun opponents communities, is whether states are free to regulate certain kinds of weapons. Justice Scalia wrote that while it may be true that to be as effective as militias were in the 18th century, an individual would have to have a right to an M16, to bazookas and tanks. That clause, he wrote, the militia clause, cannot change our meaning, the current day meaning, the Supreme Court's current day interpretation of the right to bear arms as a more limited right. So is there a legitimate fight really about this, about whether regulation is possible, not whether you could get the votes for it, but whether it's constitutional?
Regulation of what, I'm sorry?
Semi-automatic weapons or automatic weapons.
Well, so I think we need to look closely.
Yeah.
So as to automatics, the Supreme Court has specifically said that bans on fully automatics are among those presumptively constitutional ones. Semi-automatics describes basically the majority of guns that are out there. For example, for handguns, any handgun that is not a Derringer, which is almost never seen, or a revolver, which are out there but a lot less common than before, is a semi-automatic. In fact, my sense as to why the NRA became radicalized is because a lot of people in the gun rights movement concluded that there was a broad broad force out there to try to ban either all guns or ban perhaps the majority of guns. And when people talk, for example, about bans on semi-automatics, that's an excellent example because, again, semi-automatics is the majority of handguns, certainly a majority of handguns, likely a majority of all
Well, you
guns.
we could certainly have a ban on, I'm not an expert on guns themselves, and but I certainly know about this. You could certainly have a ban on guns that shoot a certain number of bullets within a range of I don't know how many seconds.
Well, the fully automatics are the classic example of something that can...
Well, an AR-15 isn't a fully automatic, is it?
So semi-automatics and non-semi-automatics do not materially differ. They differ somewhat in rate of fire. AR-15s and other semi-automatics do not also materially differ in rate of fire. But if you are asking whether courts are likely to uphold bans in particular relatively narrow classes of guns, the answer is generally speaking they have. They've done under state constitutions. They've done under the federal constitution. Part of the rationale has been precisely because, unlike with a total ban on semi-automatics, these bans would ban only a small range of weapons and leave lots and lots of other comparable weapons available for people to own. And I'm inclined to say that the courts are going to continue to uphold those.
So let me weigh in on part of why it becomes a tricky issue in not only the political realm but also the legal realm is because the Heller opinion and generally sort of the gun rights movement is not really settled on a theory about what it really thinks that the right is about. So what Justice Scalia did in the Heller opinion, and which also happens many times in discussions, is you start talking about the right at this incredibly high level of generality. It's about self-defense. And if you start talking about self-defense, then for those people that think that they need to arm themselves against the United States government or against police officers or against some sort of government official, they get wrapped up in that, as well as those people that think that they need to arm themselves against criminals. But once we get, again, to the implementation issue, then we really get this kind of things start to break apart very quickly. So somebody like Andrew Napolitano wrote in the Washington Times that he thought that Americans should have weapons of the same power and precision that the United States government would use against them. Which, if taken to be serious...
Which is exactly what Scalia said is not the case.
Right. Which, if taken seriously, but he is voicing a kind of theory about what the amendment's for. It's about me being able to take on the United States military. Now...
All right, so what are the standards by which we should be judging what the limits on gun rights, what limits on gun rights are constitutional and what aren't? What's the standard?
I'm not sure.
What is the bright line rule, or is there none?
I'm not sure. I mean, that kind of viewpoint about a sort of legal entitlement to weapons to defeat the United States government, I'm not sure I'm not sure that anybody except Andrew Napolitano, who wants to renew his contract with Fox, is really really buys. Now, we can talk about some level of lethality that we can have sort of general debates about. But one of the issues here is thinking about, it's hard to legislate without an object about what you think the right's for. If you think the right's really about your right to protect yourself against burglars that are going to come into your home, that's going to shape the kind of tools that you use to understand the right, different than if you think it's really about the right to foment a revolution against a despotic government a la 1776, or I think, which is probably more fair, to think about freedmen in the South during Reconstruction when the unreconstructed militias or terrorists are coming after them, right? That's, but on that gradation is where all the real action is taking place.
All right, I'm going to stop you guys here and give our audience a chance to ask some questions, because we've been at it now for about 45 minutes, almost 45 minutes. Yes, sir.
What about the argument that the Second Amendment was adopted in 1790, 1791? At that time, the United States did not have an effective military. They had an extremely small army and no navy. So the fear was that if the British come back, or the French come in, we need our citizenry to be armed to defend the country. There was no suggestion that the right to bear arms at that time was to defend yourself against the United States of America. In fact, George Washington, took on the Whiskey Rebellion and all of that a little after that time. So whatever happened to that argument?
Well, I think it's fair to say that when you read sort of the founding era documents, it's about defense against the British coming back, but it's also a sense of you need to make sure that you have institutions that are going to be able to act as a check on the national government, right? That's why we have a Bill of Rights. That's why all the debates are about who's going to be able to head the militia, who's going to be able to arm the militia, how do you make sure that the militia gets armed, right? So you're incorrect on the idea about defending oneself against the government, but it's not in terms of me as an individual, it's the sense of through an institution called the militia. And like I said in my opening remarks, that argument falls to pieces, right? That argument is basically, dispensed with in the Heller case, which says it's an individual right. But where it keeps cropping back up is, okay, then what do you do about, this sort of what's kind of referred to as the anti-tyranny rationale that is intensely popular in some, in some circles, and still motivates a lot of lawmaking, both at a constitutional and sub-constitutional level.
Yeah, so I think there are three components to the answer. One of which I think echoes Daryl's. There are lots of statements about how being armed, even apart from the state governments, that the fact that the citizenry is armed will deter government tyranny. It's in the Federalist, for example. It's in various other sources. That was understood. Now, it doesn't necessarily tell us that everybody should have those same weapons that the military does. I don't think so. But there's certainly, whether you like it or not, it was certainly understood that it was supposed to be a deterrent to government tyranny, whether or not you think it's effective. Second thing is, would be very odd to say, we need to have a military force to defend ourselves. Therefore, we'll put it in the Bill of Rights that this is the particular way of defending ourselves against the British. After all, the Constitution already in its body before the Bill of Rights allowed the government to raise armies, allowed the government to maintain a navy, allowed the government to control state militias. If it's in the Bill of Rights, it probably is an attempt to constrain the government from doing something that people see as despotic, and not as a means of making sure that the government can defend itself adequately.
And third?
Pardon, and third, if you, I was thinking of setting that aside, but the third, if you look at state constitutions, which also talk about right to bear arms, from 1776, which is when Pennsylvania had this, on through the framing era, on through the early 1800s, Lots of them talk about right to bear arms, including right to bear arms in defense of themselves and the state. So indeed, as a means of protection of the polity, but also protection of the people themselves. And it's possible that the Second Amendment secures a right that means something completely different than those state constitutions do. It just doesn't seem very likely.
Yes, sir.
We have a basic problem that we have too many guns. We have too many guns. We have too many people with guns. Those people and those guns are causing too many murders. We can't seem to solve it. The legislatures can't solve it. The courts rule against the legislatures often. The Constitution trumps all. Is there a solution to this conundrum? Too many guns, too many people with guns, too many murders, or are we stuck with it forever?
Well, once you assume a conclusion, it's easy to get to that conclusion. Now, as it happens, almost no gun controls have been struck down by the federal courts. The DC handgun ban and the Chicago handgun ban, which were extraordinary by American standards, were two exceptions. The Third Circuit decision, just see, it limits the ban on felons in possession as to a tiny, tiny range of felons. A few other things like the stun gun bans were at least cast into serious doubt by a recent decision, very much in the margins. The constraints on gun control in America, rightly or wrongly, are predominantly political and not legal. Now, as to if our problem is too many people with too many guns and what do you do about it, you know, it's an interesting question. There's lots of criminological debate about it. I'm not persuaded by this, but I am quite confident. Now, there are 300 million guns owned by households which house probably 130 to 150 million Americans, almost none of which are ever used criminally or for fatal accidents or something like that. So I'm not sure the problem is that too many people own too many guns. There is a small set of people who end up criminally using those guns. So the question is whether it is both politically feasible and wise to try to disarm the public as a whole, to try to solve what you describe as the too many guns problem,
Eugene,
in order to solve that.
we have a lot of people with
Fair
a lot
enough.
of questions, so
Fair
I'm going to
enough.
get you to
So that's my answer.
deprofessorize yourself. Yes, back there.
Should we wait for them? Thank you. I'd like to sort of switch this a bit and related to politics. As was suggested early on, what is the law is what the Supreme Court has done most recently. So it's argued that if Hillary wins, she appoints a justice who will, the other four, quote, liberal judges will reverse Heller. I'm curious to, I don't think that's very likely, but I'm curious, but that's the argument that's made. It says, I really don't like Trump, but I can't vote for Hillary because. I'm curious as to what your...
I'm the political expert here. On confirmations, I'm the political expert. I cannot imagine a Democratic nominee to the Supreme Court in modern America leaving open the question of whether Heller is in doubt in his or her mind. Because it's, as Eugene and Daryl point out, it's the easiest thing in the world to say, I think this is settled law, but there's still a lot of open questions about what the fine print means.
Why is it settled law? I mean, the law was, as has been described in the 30s, it was interpreted that it was not an individual.
I'm not talking constitutional
No,
law.
it's politics.
This is politics.
It's settled in the sense that the Democrats are not running around saying, unlike with Citizens United, for example, we want to overturn Heller.
No.
Or the Republicans saying, we want to overturn Roe versus Wade. It is not part of the political agenda. I think that the incremental sort of small movements of Justice Roberts in particular would, but even Justice Kagan maybe would be very leery about suddenly switching 180 degrees. I see it as settled law. The problem is that it has little to no political traction, and that is because of the paranoid style of American politics. Oh, that's what you say, but Hillary really wants to take all our guns. No, but no, it doesn't matter how many times her or Obama says, I think Hillary stole the law. There's a basic lack of trust, and so, I mean, that's what generates votes.
It's only paranoia if it's unreasonable fear. I don't think there's anything unreasonable to assume that a nominee from the liberal wing of the Democratic Party or their judicial equivalent will take the same view that Breyer and Ginsburg took twice, and unless I'm mistaken, Sotomayor was on the court for McDonald, and will take the view that in fact Heller was mistaken, and although many, a senator and a president might be reluctant to outright say we want to reverse Heller, once you're a justice on the Supreme Court, you could do that.
But
it wouldn't make a difference.
But in the Catano case was 9-0, where all the justices said, Heller is controlling law, and that's why we are remanding this back to Massachusetts to say, do the right analysis with regard to stun guns.
I'm very pleased by the result in Cayetano, but if you're asking, is it certain that a Democrat-appointed justice is going to reverse Heller? Absolutely not certain. You can tell a story about how they might say, you know, it's actually better for the country and better for our view of the Constitution if we at least say that we're preserving it, even though it basically means virtually nothing. Is it possible that one of them will say, you know, Breyer and Ginsburg were right, Sotomayor was right, that Kagan will join those three, and the new justice will do the same and say, you know, this decision was sort of an overreach by the conservatives 5-4. We're going to cure that ourselves 5-4. Eminently possible. There's nothing paranoid about thinking that. It's not certain, but it seems eminently possible.
I mean, I don't think you can have it both ways is the problem. If you say, on the one hand, that, and you have conceded a great deal, that concealed carry regulations are constitutional.
Heller said that.
Yes, that Heller says that, and that Heller says you don't get to have a bazooka or an automatic weapon if the Congress decides to outlaw it. And you don't get to do this and you don't get to do that, and that really it's the state legislatures that have been legislating fewer and fewer regulations and opening the doors to more and more gun rights, then, you know, I don't, you know, Heller protects all the federal power there is that the so-called liberals would want to exercise. They don't have to overrule Heller.
No, but they may sincerely believe it. I'm not accusing, by the way, of the prospective liberal-appointed justice if Hillary Clinton wins, which seems pretty likely. I
don't think it's so likely.
I'm not accusing that person of being insincere. I think they just sincerely believe that Heller was wrong, and being Supreme Court justices.
But Eugene, you don't have to believe that something is wrongly decided to still say we're stuck with this. This is Scalia did that all the time.
The dissenters in McDonald, who basically their dissent was on the question of incorporation against the states, but it was pretty clearly an argument against Heller as well. They could have said, look, you know, we're going to go along with this, so what's going to fall? The Chicago handgun ban, big deal. No, they took the view that Heller was wrong, and they're going to continue this argument. I don't see how certain we can be, or how we can be certain that future liberal justices will just say, no, we're going to go along with it. Maybe they will, but quite likely they won't.
But the problem with this is, I mean, it is a political argument.
Yeah.
It's very I mean, it's political, but the issue is that we have a system of politics that is supposed to structure these types of fears, right? We have a system that is supposed to say, when the Supreme Court rules on something, that's going to be the rule of law. Now you can appoint new justices, all that kind of stuff, and that might change. But trying to actually develop policy on the fear that a right that has been established by the Supreme Court at some point is going to be upended, right, is just to basically fall into what can be a kind of damaging single issue voting, right? Nothing
like the
else
abortion rights movement.
Yeah.
All right. I think the abortion rights movement is quite reasonable in fearing that if the Republicans win, Casey will be overturned. I think the gun rights movement is quite reasonable in fearing the same thing about Heller.
But
That's not paranoid.
But I don't see. But you can at least see, right, in the cases after Roe versus Wade, you can see cases that cut them down. We've got one case post Heller and McDonald, right, and that case has said, there is a right to keep and bear arms. We have to remand it to Massachusetts to see whether or not, in fact, a stun gun counts as an arm under whatever test we're going to have. The evidence doesn't show that.
Well, there are two cases after Heller. McDonald, which
Well,
also
fair
involved
enough.
guns and a deep national controversy, and Cayetano, which involved an extremely tangential thing, which probably most people, I actually wrote about stun guns, so I knew about this. Most people probably didn't even know that there still are several states, plus D.C., that ban stun guns outright, even though guns are allowed there. So you have Cayetano, which is this case about the Massachusetts court really just completely ignoring pretty much Heller, which I think is not very important. And you have McDonald, which actually was about something important. Again, nobody on the court said, I'm going to go along with the majority's decision, kind of a Harlan-esque, it's the law, I may disagree with it, but I view it as settled. Nobody viewed it as settled then. Why should they view it as settled now?
I think, the other thing to remember, of course, is my point, is that it's a floor, it's not a ceiling, right? So I have fairly high confidence. I would probably put money on the fact that Heller is not going to be reversed anytime soon. I
don't bet very often, but I'd bet
I
that too.
feel very strongly about that, right? So, but even if it was, look how pro-gun many states have entrenched their particular rights, saying that you have a gun, right to carry a gun into a lecture hall at the University of Texas, saying, for example, in Florida, which is right now being litigated, that physicians cannot ask the patients about whether they have guns in their homes. Because it interferes with their privacy, and the government has a Second Amendment interest in protecting that right. Even if Heller was to be overturned tomorrow, it's going to have almost zero effect, it seems to me, on what the law would be in Oklahoma or in Texas
Right.
or any of these states that really, really love guns.
So gun rights supporters are like abortion rights supporters. Abortion rights supporters in California would not be terribly moved by somebody saying, if Roe and Casey are overturned, sure, maybe there'd be abortion bans in Mississippi, but you in California, you could have all the abortion rights you want. That's actually something I'm sure people care about, their rights and the rights of those who live around them, but they believe that this is a fundamental human right. You can agree or disagree with it, but that's a right that ought to be protected throughout the country, perhaps throughout the world. Gun rights supporters are kind of like that. Gun rights supporters in Oklahoma, if you tell them, well, it's only the rights of New Yorkers that are at stake. New Yorkers and New Jerseyans and DCers and Marylanders and Californians, but not yours in Oklahoma. Some of them would say fine, although others might say, well, once enough of a movement grows, things change politically over time at the federal level. But many of them would say, I believe that the rights of my fellow citizens in those other states need to be protected too. Now, again, you may disagree. You may think that that's not really the right way of reading the right or whatever else. But I can certainly see why gun rights supporters are not terribly impressed by the fact that the states in which they overwhelmingly live will continue to protect gun rights. They actually do care about the gun rights of other Americans too.
But you're bad and I'm bad. That doesn't mean that we're both right.
Let me ask if there are any other questions. Yes.
So if you have this individual right to guns, right, which we do after 2008, right, constitutionally, the state can restrict rights, like hate speech if you narrowly tailor things.
No, there is no hate speech exception to the First Amendment.
Right, so you can narrowly tailor laws to restrict.
The Supreme Court has never upheld a
fundamental
hate
rights.
speech law, however narrowly tailored.
Well, so in that case, and in any case, at what point do you get enough evidence that guns are enough of a public health concern that there would be a state law sufficiently tailored enough to go beyond this restriction?
It's already part of the law, right? Nobody has a right to build a nuclear bomb in their basement. That's a cost-benefit analysis, right? Yeah, somebody that had a nuclear weapon and carried it around, really, really safe.
Or a dirty bomb.
Right, really safe. No one's messing with them. But the law already says no, that's not. That's a dangerous and unusual weapon that can't be protected. So there's already in the standards and mechanisms that we have sort of something that's baked in. The real question is, whether the standards for figuring out what kind of arms are protected and what kinds of arms aren't protected follow that same type of logic or follow some other logic. One logic would be about unreasonably dangerous. That is, the benefits of the arm are eclipsed by the costs. Another way of saying it is it's just a nose counting. What kind of guns are out there in the market? Those guns are protected, all the other guns might not be, right? And that's two ways of trying to think through this very point.
Professors always have countless ways to think through things. Let me just see if
Okay.
there's a, yes, ma'am.
Well, a couple of things here about the Constitution, actually. It does say in our Constitution, although no one ever speaks about it, that if you forfeit your responsibility towards something, you will automatically forfeit your right. That's one thing. Secondly, many countries around the world have changed their constitutions or amended different parts, tweaked their constitutions, whatever you want to call it, in order to fit the 21st century idea of what's happening, the crime, the laws, and so on. When has our country ever done something like this, or never, or
Well, you
is
and I
this a
wouldn't have the right to
possibility
vote
to
without that.
amend? Well, you don't have a right to vote. That's a lovely thing that's given to people, but it never works. But the idea of setting up something, okay, if the laws are open to such wide interpretation, maybe we ought to look at keeping the laws, but making them fit, putting different amendments to them, specifying when certain things are needed and when they're okay and when they're not okay, and specifying this into the law and making sure that this is practiced throughout the states.
You each get exactly 1 minute and no more for this answer.
I mean, Eugene and I did a double take because I'm not
Yeah.
sure what I'm not sure about the forfeiture clause
There
that
isn't
you're talking
one.
about. But look,
No, it's not in the Constitution.
our Constitution. I mean, look, our Constitution is pretty old. Jefferson, I think, had the plan that maybe we should have a constitutional convention every 20 years or so and sort of refresh it with every generation. But that's not the Constitution that we have. We have supermajority requirements to amend it and so forth. So. Where the sort of fine-grained what makes good policy, what doesn't make good policy, who should make that policy, that all gets played out in terms of litigation. And so the main debate, right, in gun rights, but also abortion and a number of other areas is how much of this is something that judges are really good at and should be doing, and how much of it is they should say, look, as Justice Holmes said, if the people of the United States wants to, go to hell, who am I to stop them, essentially?
One more question.
Yeah, let me just leave things to
Okay,
next question.
one more question. Anybody over here? Anybody over there? The back of the room.
At the beginning, Nina Totenberg read the Second Amendment. Whatever happened to the right to a militia? Wouldn't there be a linkage? Was that completely destroyed? The right to bear arms, not being a member of a militia. It's kind of odd that the militia part has been virtually ignored now, that we can simply bear arms as individuals, and we're not part of the state militia.
So Heller, right? You're right. It decouples the militia clause. It says that's prefatory. It's like a kind of this is one reason why we have something. What is that something? The right to keep and bear arms. Scalia calls that the operative clause. And so the militia is. The militia doesn't shape the right the way it did prior to Heller, at least in the understanding of, cases like Miller and so forth. But it doesn't necessarily mean that there is no militia, right? Scalia talks about, in the Heller opinion, about this unorganized militia, which is all people or all virtuous people, or we're not quite sure. And the way that the militia, in terms of litigation now, comes back in is not as a constraint on the right, but as trying to figure out what kind of people are protected. So, for example, Eugene had talked about 18 to 21-year-olds who can't purchase weapons. There's a dissent in a Fifth Circuit case that says, oh, but these people would have been members of the militia in 1791, and therefore they should have a right to keep and bear arms. So it doesn't come in exactly the same way. But as a technical matter, it's still there. It's just not a constraint anymore.
So the Second Amendment specifically says the right of the people to keep and bear arms. And I think that's what drove the court. If it had said the right of the militia to keep and bear arms, that would be pretty easy, right? If it's only to the militia. But it doesn't say that. It says the right of the people to keep and bear arms. The Constitution talks about right of the people in other contexts, to peaceably assemble and petition the government, right of the people to be secure against unreasonable searches and seizures, and that's why the court concluded it is a right of the people, of you and me. Now, it's the militia clause, the court concluded, and I think based on the way these documents were written and interpreted around that era, I think this was right, although others disagree, is part of the justification. The justification is because we want to have a well-regulated militia, which is necessary to secure, and free state in this case meant basically free country, a non-tyrannical government, a nation that's non-tyrannically governed. Because of that, that's why the people have this right. And one of the things it pointed out is the militia then, and even today under federal statutes, was actually basically defined not as some National Guard. It was basically 18 to 45-year-old. At that time it was white males. Today it would be without regard to race or sex. So it was basically at least a very large chunk. 45, I like to think, today is the equivalent of, is very young by historical standards. So it was basically a considerable chunk of the citizenry. So the court concluded that it basically means something like, because an armed citizenry, albeit one that's also well trained to arms, is necessary to protect freedom in a free country, the right of the people, which is to say you and me, to keep and bear arms shall not be infringed. Now, that may or may not be correct, and again, there are arguments both ways, but what really drives it, I think, is the fact that the right is labeled as a right of the people and not a right of the militia.
Okay, it falls to me, I think, to close, and I don't think we've resolved anything, of course. I would just like to observe that Justice Scalia was the first real proponent or modern day proponent of originalism, or as he later said, textualism, actually, and so sort of qualifying that on the Supreme Court. And we all miss him very much, but I will say to you what I often said to him and got another shrug, which is that the ink was barely dry on the Constitution before the very people who wrote it started disagreeing about what they meant.
True.
So, the fact that we have resolved nothing today means, we can take heart in the fact that the founders really couldn't resolve what they meant either. So thank you very much for coming. Thank you for having me. Thank you to the Ashland Institute.
We may not have resolved anything, but we kept our promise to provide a very lively debate. Thank you to our participants. Thank you, Nina. And thank you all for being here. We hope to see you at our next event. Terrific. Thank you.